Good morning and welcome, everyone. I'm Karen Cross, Chief Executive Officer of the Greater Kingston Chamber of Commerce. Between maintaining business continuity and keeping your workforce safe, we know there's been little time to track the rapidly changing labor, employment, and human rights law landscape in Canada. Today's webinar will address these changes and provide insight into confidentiality clauses, sick days, minimum wage, vacation entitlement, and employment contracts and policies. We are proud to partner with Pro Bono Student Council, Queen's University chapter, to provide law students with rewarding opportunities to volunteer on projects that align with their skills, experience, interests, and education, with the aim of promoting greater access to justice in our community. With that, I'll pass it over to Jessica for a few words.
Perfect. Well, thank you so much, Karen, and good morning, everyone. My name is Jessica Colvin, and I'm the Manager of Business Development and Member Services here at the Chamber. So we do have an exciting presentation planned for you today. Just a couple of things to note, though, before we get started. One is that today's session is being recorded and will be available for viewing on our YouTube channel later this afternoon. We've also allotted time for question and answer at the end of the session, but encourage you to enter your questions in the chat as we go along. Now, I would like to pass things over to Rina Youssef, JD candidate for 2022, Queen's University Faculty of Law, to begin today's presentation.
Thank you, Jessica. Hi, everybody. I'm Rina, and I'm with the Pro Bono Students Canada Queen's Law Chapter. Me and my group are very excited to be here today. We've been working on this presentation for a while, so we are excited to finally be here and present to you, and we hope everybody enjoys it and learns something new. So I'm going to share my screen now. Oh, would I be able to get privileges to share my screen?
Yes, absolutely.
Thank you.
You should have it now.
Perfect. All right. Let me know if everyone can see that. Good. Perfect. All right. So I'll start us off. So like I said, we're the Pro Bono Students Canada Queen's Law Chapter, and we're partnering with the Kingston Chamber of Commerce to give you your presentation today. So just to give everybody a rundown of what we will be addressing, we're going to start by looking at the review and preparation of a contract. Kevin will be starting us off with that. Then we're going to look at the confidentiality clauses in contracts, sick days, vacation entitlement, as well as minimum wage standards. I do want to note that all the information in this presentation is not legal advice, it's legal information. So why don't we get started with the review and preparation of a contract.
And policies. Thanks, Rina. So I'm just going to quickly get us started with the basics, which would be the next slide. And here we go. So the main thing you want to keep in mind when we're doing employment contracts is the fact that along with statutes and the common law, they sort of form one of the pillars of employment law. And in Ontario, you know, all of these sort of employment contracts, whether they're written or verbal, are still binding. So that's important to note because they can take form of a simple conversation or a highly multi-page document. Now, noting that, it's important to note that the difference between an employment relationship and how it can generally and must generally actually comply with the Employment Standards Act, or as you'll see in this presentation, often referred to as the ESA. So when determining if there is an employment relationship between two parties, you're going to want to see to make sure that there's an objective analysis that's going to be applied by the courts. And the purpose behind this is to see if the agreement was formed. In the next slide, you'll see more information about this. But the general takeaways is that an employment relationship is formed once an employment, discussion occurs. And then from there, an employment contract will outline all the terms within that agreement. You might even get into several sort of questions to determine if you're working with an employee or a contractor. And from there, you will actually want to consider probably reaching out to a lawyer in that context. As when you're dealing with these things, it's important to note that contractors fall within two categories. There are independent contractors and dependent contractors, with dependent contractors being more economically dependent on their employers than their independent counterparts. So during these things, you might want to note that dependent contractors, since they are economically more dependent than independent contractors, they're entitled to a lot of the same benefits that you might recognize in an employee. Again, this is the relatively complex area of law and why you'd want to contact a lawyer for some help when dealing with it. Because, well, you can run into some serious legal issues if you don't. Yeah, so as mentioning before, employment relationships, to see if there is one that's formed, the court's going to generally apply one of these more objective tests. And it's important to know the difference between the different types of contractors just to avoid any legal issues you might see there. Right, and this is just a summary of that again. So now it's important to know when an employment relationship itself might begin. So as mentioned, they might begin as soon as a relationship is formed. Now, the relationship can be formed as soon as an employee and an employer agree to perform things for one another. This is called consideration, and we're going to get into it more in detail later on in the presentation. And once again, the contract just sets out the terms for this agreement. So at this point, you might be wondering, why is it important to have a contract? Well, as noted before, verbal contracts are equally binding. So because of that, it's always great to have something in writing. This sort of creates a paper trail. So you can sort of backlog through things and actually be able to see what you've agreed to and what your employees have agreed to. You know, once the contract is formed, it allows an employer to really shape the responsibilities of their employees to match their needs. This allows for a lot more efficiency within the workplace, as you won't have to necessarily create a new agreement or contract every time you'd want a new task performed. Having a written contract also allows for modification and to set out terms from the onset. So as the relationship matures and grows, you can make several modifications to it to match the evolving needs of your business or your workplace. Again, creating much more efficiency. Now we're going to get into, once you have a contract, is it actually enforceable? Because that's kind of a big deal. When you have a contract in writing, that doesn't necessarily mean it's enforceable. Even verbal ones might not necessarily be enforceable. So they're not going to be enforceable if they're made with a lack of consideration or if they fail to comply with the ESA. You know, this is the most common sort of issue that lawyers see in employment law. And as such, you'll probably want to contact a lawyer if you have that kind of issue. Additionally, if the agreement is unconscionable, made under undue influence, or made under duress. So no threatening people to make contracts. Next, we're going to get into the importance of updating your contracts periodically. As mentioned before, contracts and employment relationships evolve over time, and the sort of needs of an employer might change over time. That's why updating your contracts periodically is very important, as you want to always reflect the current nature of the employment relationship. Additionally, they'll create a paper trail, which again, we'll get into later, but noting all the changes in the terms of an agreement is very important as it prevents issues involving things such as constructive dismissal. Now, again, it clearly outlines what the employer and employee are agreeing to, which is great for people like me who might forget what we're supposed to be doing. And, you know, sometimes with a contract being updated, nothing might change. It's also a good note to make, you know, in noting that there might not be any changes at all, but it's great to date that these conversations and negotiations happened. Next, we're going to get into employment policies. Now, having workplace policies is critical to ensuring a safe and efficient workplace. Now, policies set out more detailed expectations of employees within certain circumstances inside the workplace and while performing their work. These policies, again, can extend beyond just the simple work, but how you're supposed to act within the workplace as well. So as noted, you know, not all policies are mandatory, but many of them are. Here's a list of the mandatory ones as of July 7th this year. They include health and safety policies, which again includes workplace harassment and workplace violence policies. There's workplace hazardous materials information system. If anyone's familiar with WHMIS from high school, it comes back. That also includes hazardous specific policies. There's accessibility policies, emergency and preparedness and response policies, pay equity policies and plans, non-smoking policies, and disconnecting from work, which is ultra relevant for the current day and age. Just going to get a bit more into disconnecting from work. See, Bill 27 amended the ESA, and as effective of June 2nd, 2021, so as it impacts us now, employers with 25 or more employees must have a policy in place with respect to disconnecting from work so as to stop employees from generally having that sort of online burnout that we're probably all familiar with. This accounts for employees across various locations, such as, for example, if you have 3 locations, it's not a total of 75, but rather still 25. After this policy comes into place and your workplace administers it, they have about 30 days of it actually being prepared to put it into action. Along with that, after terminating one of these policies or improving upon it, you're going to have to keep it on record for about 3 years. Again, going back to the importance of creating a paper trail in updating contracts. Next, we're going to go into common policies. They're not mandatory, but they're still very useful and very common to have in the workplace. These include things such as anti-harassment, anti-discrimination, and accommodation policies. You'll see things such as benefits and bonus plan policies, progressive discipline policies, alcohol and drug policies, code of conduct policies, privacy policies, social media and computer use policies, and overtime policies. Additionally, probably the most important thing about having policies is that you're going to find a way to communicate them to your employees. See, policies can be conferred in various ways, such as posters, training, handbooks, databases, as long as they're communicated some way. That is the important thing. Now we might be thinking about terminating me, but we're moving on to the section of terminating contracts. Now, the 2 things you want to focus on are the Employment Standards Act and if the contract included a termination clause. Once you've reached those conclusions, you want to move on to the second stage, which is determining if a contract was frustrated or abandoned. Now, a contract is frustrated if due to unforeseen circumstances, it can't be performed and thus is rendered void. Now, if a contract employee doesn't want to renew or doesn't agree to the new terms of their contract, this is considered abandoned. Finally, we're going to move on to terms. The terms of a contract are the material details, otherwise the main important details that define the employment relationship. Common issues that happen here often revolve around changes to terms, reasonable notice, competition clauses, solicitation clauses, or non-disclosure clauses. So regarding changing to terms, unless they're clearly set out, changes to essential terms could result in constructive dismissal, as I've mentioned a few times. Now, constructive dismissal refers to any sort of change in the employment agreement that would make the original agreed upon work done impossible to be performed under the termination of an employee, which doesn't sound legal, so probably shouldn't try to do that. Again, this is where having an employment lawyer might be a great idea. So next, we're going to go into reasonable notice and the amount of notice that an employee is entitled to in the event of termination. Now, typically within Ontario, it's 1 month for every year of service, but this is very context dependent. And you might notice the ESA minimum is that of 8 weeks, and very rarely are employees awarded more than 24 months of notice. Next, we're going to move on to competition clauses. See, this prevents employees from setting up competing businesses with their former employers and employees who might even just join a competing company. Now, this can happen during or after the employment. And again, non-compete clauses generally help restrict this behavior. Again, with solicitation clauses, just like non-compete clauses, this can happen during or after the employment, and they generally prevent employees from soliciting members of the staff or clients of their current employers. Again, we're going to go into non-disclosure, similar idea, but it involves discussing employers' confidential information and happen during or after. Now, Lindsay's going to get into more detail with this, so I'm just going to quickly pass it off to her, if that's okay with Lindsay.
Awesome. Thanks so much, Kevin. So like Kevin said, I will be discussing confidentiality clauses today. So as Kevin just mentioned, so a confidentiality clause is actually a type of restrictive covenant. And before getting into that, I did want to briefly explain a little bit more about the 2 other common types of restrictive covenants that can be found within an employment agreement or contract. As Kevin mentioned, the first one is a non-competition or non-compete clause, and the second being a non-solicitation clause. So a non-compete clause, it does prohibit an employee from starting a business which is competitive to the employer, However, it should be noted, though, that these type of clauses are mainly precluded under the Employment Standards Act due to the new Ontario legislation, Bill 27, that Kevin did mention. And then as well as two non-solicitation clauses. Those do prohibit departing employees from soliciting clients, customers, other employees with whom the employer has had business dealings with. Now, these types of clauses are not prohibited under the ESA, but will only be enforced in court if the clause is demonstrably reasonable. So typically, non-compete and non-solicitation clauses are difficult and generally unenforceable, whereas in comparison, a confidentiality clause is subject to far less judicial scrutiny and is generally much more enforceable while still sufficiently protecting an employer's business interests. So that being said, what exactly is a confidentiality clause? So it's very likely that an employee may obtain important confidential information during their course of employment. So a confidentiality clause prohibits an employee from improperly using and disclosing information that is not public knowledge and is considered confidential to the employer. These can be used both for during and after the termination of the employment relationship, and generally confidentiality clauses serve to let an employee know what work-related information they can use or disclose. Now, if an employee uses or discloses that information inappropriately, then an employer can take them to court. So essentially, a confidentiality clause can be one of the best ways to protect confidential information prior to disclosing that information. And the most common breach of confidence is when an employee misuses a former employer's confidential information to compete for its customers, corporate, or any other employment opportunities. So what is confidential information? So confidential information is non-public information that makes it a valuable business asset the employer finds critical to protect. So confidential information must be specific and not just general in nature. It really needs to be a matter of substance rather than just a trivial detail. It does need to be communicated in confidence, either by the employee being told expressly that it's confidential, or the character of the information is obviously confidential. It cannot be common knowledge that's accessible and used by competitors, and if it's disclosed, would cause serious detriment to the employer. However, it should be noted that the skill, knowledge, and experience that an employee learns during their tenure with the employer will not be considered confidential information, and rather this is known as general knowledge. So for example, the organization and management of an employer's business is not considered confidential. And as I mentioned, an employer's technical skills, abilities, and aptitude is also not confidential information. So how do we define confidential information? So employers should make the definition of the term confidential information, broad enough to cover all the information the employer may disclose to the employee, but also specific enough for the employee to determine what information is actually being protected. So there are various types of confidential information, as you can see listed on the slide. It can range from customer, supplier, and vendors list, to financial and sales data, to commercial contract, business, marketing, and sales plan strategies and programs. So what can be considered in a confidentiality clause? So a confidentiality clause within an employment agreement should include what information is particularly important to the employer. Employers can and often should get creative when thinking about what they want to include and cover within a confidentiality clause. So for example, information that is of economic value, whether actual or potential, value to the business and to competitors, and it's used in a trade or business. And then when is it best to actually give an employee a confidentiality clause? Typically, it's best to give them prior to the employee actually commencing their employment. Typically, a confidentiality clause within the employment agreement or contract is sufficient. However, an employee can agree to a confidentiality clause during their employment or at the time of termination. However, if this is the case, if it's given after employment has started, it will be unenforceable, even if the employee agrees to it, unless proper consideration is given to the employee by the employer. So consideration must be something of value to the employee, which they are not already entitled to, given in exchange for them agreeing to uphold the confidentiality clause. Consideration can get a little bit tricky, but it can be something like a promotion, a one-time payment or bonus, or pay raise, but has to be something more than a $5 or $10 Timmy Starbucks gift card or an extra break one day. And lastly, I just wanted to talk about the return and the destruction of confidential information. So a confidentiality clause should require an employee to return any confidential information, including electronic and hard copies, at the employer's request or at the time of termination. However, the employee can have the option requiring the employee to destroy the confidential information and have the employee certify in writing that the information has been destroyed. However, this option does have an inherent risk, as there is no way for the employer to know for certain that the information has been destroyed. And lastly, I just wanted to discuss that there are some limitations to confidentiality clauses, such that information will only be protected from disclosure while the employer keeps it confidential. If the information becomes available to the public, the duty on the employee to maintain confidence is now gone. So I hope you guys learned a little bit about confidentiality clauses. They can get a little complex as well, but I will take it away to discuss sick days.
Thank you, Lindsay. So as she mentioned, I'll be sharing some information about Ontario's current sick leave entitlements. So starting with the Ontario COVID-19 Worker Income Protection Benefit, which I'm sure many of you are already aware of. But on April 29, 2021, this protection benefit came into effect and the Employment Standards Act was amended. This entitlement is available retroactively from April 19, 2021. So employers are now required to provide eligible employees with up to 3 days of paid infectious disease emergency leave because of certain reasons related to COVID-19. And note that this is 3 days total for the entire period that the entitlement is in effect. So it's 3 days from April 19, 2021 to July 31st, 2022, which is when the benefit will continue until, and it may be extended further. And this is not 3 days that are annually renewed. So the benefit is available to employees who are not already entitled to 3 or more days of equivalent or greater compensated leave for similar reasons under their existing contract. So it's not an automatic additional 3 days of leave. And it's available to employees who are unable to work or perform their work duties for 1 or more reasons related to COVID, including getting tested and awaiting their results, getting vaccinated, experiencing side effects from the vaccine, being under medical treatment or self-isolation because of COVID-19, or providing care to a dependent who is sick or self-isolating because of COVID-19. So the employer's eligibility for reimbursement depends on what other rights their employee has. So the employer will be eligible for reimbursement if at least one of these conditions apply. So firstly, the employee used some of the paid leave in their employment contract before April 19, 2021, so that they didn't have at least 3 days of paid leave remaining, or the employment contract provides less pay than the benefits, or the employment contract is more restrictive in terms of the conditions required for taking this type of paid leave. So eligible employees are entitled to be paid their regular rate of pay up to a maximum of $200 per day, and this does not include overtime and or holiday or premium pay. The employer must pay the eligible employee, and then they will apply to reimbursement at the Workplace Safety and Insurance Board within 120 days of paying their employee. Note that if an employment contract already provides 3 or more equivalent or greater paid sick days, then the employer is not eligible for reimbursement if those days happen to be taken by the employee for reasons related to COVID-19. And an employer can't cancel an employee's existing entitlements in order to receive this benefit. So we'll talk briefly about the unpaid infectious disease emergency leave, which is a right that employees have to take unpaid job-protected infectious disease emergency leave if they're not performing their duties for reasons related to COVID-19. So currently, the only infectious disease that qualifies is COVID-19, and the employer cannot threaten, fire, or penalize an employee for taking this leave And the reasons that an employee might take this leave are exactly the same as the ones that we mentioned earlier, which includes like getting vaccinated or self-isolating, etc. So now we'll talk about general sick day information. So under Section 50 of the Employment Standards Act, an employee who has been employed by an employer for at least 2 consecutive weeks is entitled to a leave of absence without pay because of a personal illness, injury, or medical emergency. And the employee's entitlement to leave under this section is limited to a total of 3 days for each calendar year. So an employee can take this leave for, I mentioned in the Act, for illness or medical emergency, and for example, surgery that they have plans coming up. But they would have to provide reasonable evidence, and we'll get into that later. So this is up to 3 days of unpaid job-protected sick leave every calendar year. So an employee who begins to work partway through a calendar year is still entitled to the 3 days of leave for the rest of the year. And the sick days do not have to be taken consecutively, and they cannot be carried over to the next year. So this applies to full-time and part-time employees. The employee must inform the employer before starting the leave, and this is also in the Employment Standards Act. But if the employee is unable to inform the employer for whatever reason before starting the leave, then they must inform the employer as soon as possible. And the notice does not have to be given in writing. Oral notice is sufficient. And the employer may deem part of a day as 1 day of leave, but they don't have to. And if an employee takes part of a day of leave, then they would be entitled to any wages that they earned while working in the other part of the day. And the employer may require the employee to provide evidence reasonable in circumstances. So it depends on the actual circumstances of the situation. So the employer may be entitled to ask for a medical note, but keep in mind that the employer can't ask for information about an employee's diagnosis or treatment. So we have an example to illustrate some of the general sick day entitlements. So let's say Val leaves work early because of a severe migraine. Then she has the right to be on sick leave for her half day, and her employer doesn't have to count it as a full day of sick leave, but they can if they want. But the only way that the employer can count it as a full day of leave if she only takes a half day is when they're determining if Val's 3-day entitlement has been used up. They still have to pay her for the half day that she worked, and they can use the hours that she worked in that half day to determine if she's worked overtime, if she's reached her daily or weekly limit on hours of work. Note that if the employment contract provides a greater right or benefit than the Employment Standards Act standard for general sick days, then the terms of the contract would apply instead. So for example, a contract provides for 1 paid personal sick day per year and no other job protected time off. If the employee takes that paid sick day off under the employment contract, then it would be as if they took it off under the ESA as well. So the employee would have 2 job protected unpaid sick days left in the calendar year under the ESA and no more paid sick days left under the contract. So far we've looked at the review and preparation of employment contracts, confidentiality clauses, and sick days. And now I will pass it on to my colleague Ruth to talk about vacation entitlement.
All right, so thank you, Ella. My name is Ruth, and I will be discussing the topics of vacation entitlement and holiday pay. So just to begin, I want to differentiate between vacation time and holiday time. So vacation time is time off work in which an employee receives pay, but they don't have to work. And the number of days an employee is entitled to for vacation is dependent on the number of years they have been employed. Alternatively, holiday time is paid time off due to a public or statutory holiday. Most employees are entitled to have these days off, but there are some exceptions that I will touch on a bit later. And entitlement depends on the date of the holiday. And I just want to point out the differences between vacation time and vacation pay. So vacation time is the actual number of days an employee gets off work within the entitlement year. And vacation pay is payment an employee receives when they go on vacation, and it accumulates from the moment an employee begins working and is earned after every paycheck. So the amount of time an employee is entitled to for vacation depends on their number of years of employment, as I noted earlier. So if an employee has less than 5 years of employment, they get 2 weeks of vacation day, 2 weeks of vacation times after the completion of a 12-month vacation entitlement year. And this must be taken subject to the block rule. So the block rule requires that the vacation must be taken in 1 2-week block or 2 1-week blocks. If an employee has 5 or more years of employment, they're entitled to 3 weeks of vacation after completing the entitlement year. And again, with the block rule, this must be taken with 1 3-week block, 1 2-week block, and 1 1-week block, or 3 1-week blocks. And just a final note on this slide, while employers don't need to provide vacation time until after the 12-month entitlement period is complete, most employers do allow their employees to take vacation before this by giving their employees their minimum vacation entitlements in advance. So there is an exception to the block rule where an employee may take shorter periods of vacation if they make a written request and the employer agrees to this in writing. It's important to note that employers they don't need to agree to these requests. It's to their discretion. But in the event, if they agree, they must calculate the number of vacation days the employee is entitled to. So if an employee has a regular work week, so they work the same number of days each week, in total entitlement is calculated by multiplying the number of days in a work week by 2. So an example of this is if an employee works 3 days a week, then they're entitled to 6 single vacation days. Alternatively, if an employee doesn't have a regular work week, entitlement is calculated by multiplying the average number of days worked each week in the last completed entitlement year by 2. So there are 2 main entitlement schemes used by employers. So the first being that the entitlement year begins on the employee's first day. And the second and more common method that's used is an alternative scheme in which the entitlement year doesn't begin on the hire day. So an example would be the first day of the calendar year. Most employers follow this alternative scheme because it gives them the ability to standardize their operations and calculate employee entitlements according to the same timeline. There will often also be instances where an employee begins before the start of the next entitlement year. So when this happens, employers must account for the employee's prorated entitlement between the beginning of their employment and the beginning of the next entitlement year. So there are some requirements that vacation must follow. So the first being vacation must be taken within 10 months of the entitlement year. Employers have a responsibility for ensuring that vacation is scheduled and taken before this 10-month period ends. If an employee fails to schedule the vacation time themselves, an employer may do so on their behalf. An employment contract may also stipulate that some or all vacation time must be taken within a specific period of time. And it's also important to note that vacation time cannot be carried over into the next period unless it's permitted by the employment contract. So if they don't use it, they lose it. And in the event that an employee forgoes their vacation entitlement, there are a couple requirements that must be followed. So the first is there must be written or electronic agreement with the approval from the employer and the Director of Employment Standards. This is just to create a record that the employee gave up their vacation entitlement. And even if an employee doesn't claim the vacation time, they are still entitled to vacation pay. So the employer must pay out for any unused vacation time. Just an important note on this, if an employee does have to be paid out for any unused vacation time, it's important that there's a record of the amount given to the employee for the unused time. Again, just so there's a paper trail of the record of the amount paid. So I'm just going to briefly touch on vacation entitlements for terminated employees. So if an employee is entitled to a notice of termination, they are entitled to any vacation pay that accumulates during the notice period. Vacation cannot be scheduled during an employee's statutory period unless the employee agrees to take the vacation time after receiving written notice of termination. And if there is a situation where payment is provided instead of a notice of termination, the employee is entitled to vacation pay had notice been given. So this just means they're entitled to any vacation pay on wages that would have been earned if they were given the notice of termination. So the employer must pay the employee for any earned but unused vacation time. And alternatively, if an employee took vacation time and pay before it was earned, they must pay that back to the employer. So I'm going to briefly discuss the payment schemes for vacation. So if payment depends on the number of years that an employee has been employed. So vacation pay for those with less than 5 years of employment is at least 4% of gross wages earned during the entitlement year. And for employees with 5 or more years of employment, they're entitled to at least 6% of gross wages during the entitlement year. And wages include things like regular wages, commission, bonuses, holiday pay, anything like that. And then for the payment method, vacation pay must be paid as a lump sum before the employee takes their vacation time, unless one of the following exceptions apply. So the first being that the vacation being taken is less than 1 week, or the employee has agreed in writing that the vacation will be paid on each paycheck as it accumulates. The employee has agreed in writing to an alternative time for payment. And then lastly, the employee is paid through direct deposit. If an employee is paid through direct deposit, they must be paid vacation pay on or before the day for the period in which the vacation falls. Okay, so it's very important that records of if vacation entitlement and pay is kept, not just for your own records, but also it is also legally required. So employers must keep records of vacation time earned since the day of hire, but unused before the start of the entitlement year, vacation time earned and taken during the entitlement year, the amount of vacation earned since the day of hire, but not taken by the end of the entitlement year, vacation pay earned and paid to the employee, and how that pay was calculated. So these records must be made within 7 days of the start of the next vacation year or the first payday after the next entitlement year, whichever one is later. And these records must also be kept for 5 years after the date of creation. All right, so now I'm just going to move on to holiday pay briefly. So Ontario has 9 public holidays, and they're listed on the slide here. Most employees are entitled to take these days off and to be paid public holiday pay. So employees generally qualify for these entitlements unless they don't meet the last and first rule. So the last and first rule just means that an employee must work their last scheduled day of work in full before the public holiday, and their first scheduled day of work after the public holiday in full unless they have a reasonable cause. So a reasonable cause is just something that is beyond the employee's control that prevents them from working. So an example would be something like a natural disaster. In the event that a public holiday occurs during an employee's scheduled vacation time, the employee must receive one of the following. So they can have a substitute day off with public holiday pay within 3 months of the public holiday. Also, if there is a written agreement from the employee, this may be extended to 12 months, or they are entitled to public holiday pay without a substitute day off. And again, this just needs a written agreement from the employee. Just like the entitlements for public holidays, in order to qualify for either option, the employee must fulfill the last and first rule. So employees may agree to work on public holidays in writing or electronically. And if an employee does agree to work on that day, then they must be paid in accordance with one of the following. So they can get public holiday pay plus premium pay for all hours worked on the public holiday. Premium pay is just time and a half of the regular rate of payment. And if this approach is taken, then the employee is not entitled to an alternative day off. The other option is regular wages for all hours worked on that day, plus a substitute holiday in which they are entitled to be paid holiday pay. So the scheme for holiday pay is the following. So it's all regular wages earned by the employee in the 4 work weeks before the work week of the public holiday, plus all vacation pay earned during those 4 weeks divided by 20. And in this case, it's important to note regular wages does not include things like overtime, premium pay, or termination pay. So this completes the section on vacational entitlement and holiday pay, and I'm going to hand it over to Rena, who will be discussing minimum wage.
Thank you, Ruth. All right, so the final topic we will be covering today is minimum wage in Ontario. So what is minimum wage? Minimum wage is the lowest rate of pay an employer is allowed to pay their employees. So whether the employee is working full-time, part-time on a casual basis, or hourly through commission or salary, most employees are entitled to minimum wage. So the purpose of minimum wage is to ensure that all workers are guaranteed a wage that's not considered too low. So this wage may reflect, for example, the average cost of living in a specific area. Governments have historically enacted minimum wage with many goals in mind, like protecting non-unionized workers, reducing the number of low-paying jobs, alleviating poverty, encouraging people to work, and addressing inequality. Some jobs, however, are exempt from the minimum wage and the whole Employment Standards Act as a whole. So if you look on the side, there are some jobs here listed. I won't go through them all for the interest of time, but these include secondary school students working in co-op programs, police officers, young offenders, employees in jobs that are federally regulated, etc. Section 2.1 of the ESA also states that the Crown, a Crown agency or an authority, board, commission, or corporation of all those members who are appointed by the Crown and any employees of this employer are also exempt from the minimum wage and every provision of the ESA. So it's important to note that minimum wage, like other ESA rules, is just merely a minimum standard. So employers can, and they quite often do, go above the minimum standards in response to different market forces. So just to give everybody a little bit of a breakdown about minimum wage, we'll start with general minimum wage. That has gone up from $14.35 per hour to $15 per hour. This rate applies to most employees in Ontario. Student minimum wage has gone up from $13.50 per hour to $14.10 per hour. And this rate applies to students under the age of 18 who work 28 hours a week or less when in school, or work during a school break or summer holidays. I think now most notable is the bartenders, liquor servers minimum wage. that has increased from $12.55 to similar to the general minimum wage, $15 per hour. This rate applies to employees who, as a regular part of their job, serve liquor directly to customers, guests, or members in a licensed premises, and who regularly receive tips or other gratuities as part of their work. The home workers minimum wage has gone up from $15.80 to $16.50 per hour. And home workers are those who do paid work out of their homes for their employers. And finally, looking at the hunting, fishing, and wilderness guides minimum wage, it's $75 when working less than 5 consecutive hours in a day, and $150.05 when working 5 or more hours in a day, whether or not the hours are consecutive. So the minimum wage for employees who earn commission. So if an employee's pay is based completely or partly on commission, it has to amount to at least the minimum wage for every hour worked by the employee. So for example, when an employee works on commission and gets paid weekly, if they made $300 commission after working 25 hours, the employee is owed $15, which is the minimum standards, multiplied by the 25 hours, which equals $375. Therefore, the employer has to pay the employee $75. Looking at the 3-hour rule, if an employee who normally works more than 3 hours a day is required to do work on a particular day, but ends up working less than 3 hours, they have to be paid whichever of the following is the highest. So 3 hours at their regular pay, or the amount the employee earned for the time worked and wages equal to the employee's regular wage for the remainder of the 3 hours. It's important to note also that this rule doesn't apply to employees who normally work 3 hours or less, or in some cases, if the employee not being able to work a minimum of 3 hours was beyond the employer's control. As of January 1st, 2019, the 3-hour rule now also applies to students. So when does the minimum wage change? So it changes every October 1st of every year, starting this year, 2022. The new rate comes into effect on October 1st, but will be published on or before April 1st of the year. So in the interest of time, I won't go deep into the statute in the Employment Standards Act, but if you are curious, these are the statutes that govern this area. Section 223(1) says that every employee has to be paid the minimum wage, so that's where we get that from. Section 23(4) addresses the hourly rate, and section 23.0.1 addresses changes to minimum wage during a pay period. The ESA also includes some important definitions if something is unclear. So they address definitions like regular rate, regular wages, regular workday, or regular work week. So if you're ever confused, that's a good source to have. So that concludes our presentation for today. Thank you everybody for joining us. We had a lot of fun putting this together, and we hope that everybody got to learn a little bit something new today. Before we start the Q&A, we would love for you to let us know how we did. At PBSC, we just want to grow and we want to get better. So if you could fill out a quick survey, that would be great. You can actually just point your phone at the QR code and it'll lead you right to the survey, or I will also put the link in the chat, and you can just go on there and do the survey if you have time. So now we could open up the floor for some questions.
Amazing. Well, I just want to quickly say thank you guys so much for speaking with the membership today. You all did a fantastic job on your presentations. And, we're really grateful that you took the effort to share all of your research and thoughts with us. So with that, we will begin the question and answer period. Anyone can feel free to either enter it in the chat or raise your hand and we'll address them. You can unmute yourselves. It does look like we've got a couple in the chat box already, so I'll just go through those for you. The first is from Sam, and they're asking, do you have any information about employees that are not eligible for public holiday pay, such as landscaping or groundskeepers?
I'm gonna hand that off to Liam because he can probably help you a little bit more with that.
Hi, everyone. Just to introduce myself, my name's Liam McMonagle. I'm a lawyer here in town with Cunningham Swan. I've been helping the group out, making sure that all this information is, is correct and helpful for the membership. And so in response to this question, I think unfortunately I'm going to be annoying and ask a question in response, which is, what do you mean precisely by any information about employees? So Sam, if you could just follow up with that, that'd be great, please.
Yeah, is there like a general list of jobs that don't for employees that are ineligible for public holiday pay?
So just in terms of exempts, yeah, like those exemptions, as it were.
Yeah, that's right.
Right. I'd have to look into that. I'm not, off the top of my head, I'm not familiar with a precise list. So I think, as was covered in the presentation, there are those exemptions, for example, for minimum wage, that sort of thing, and there are plenty of exemptions for various minimum employment standards. But in terms of public holiday specifically, I'm not sure. So let me get back to you. I'm going to look into that very briefly.
Thank you.
Sam, maybe we'll have you, if you don't mind sending me your email address. That way, when we jump offline, I can follow up with Liam and get you that information.
Yeah,
Sure.
absolutely.
Thank you.
And Monica is asking whether or not we'll be able to provide a copy of today's presentation. So yes, to confirm, we'll be able to share that along with the recording. It should be live later this afternoon. And I'm just going to scan here if we've got any hands up. And thank you. Dave just gave some kudos and said, great presentation. Looks like Hugh McKenzie has a question. Go ahead, Hugh.
Find my unmute button. I'm sorry.
That's all right.
Can you hear me? Can you hear me
Yes.
now?
Yes, we can.
So it's with respect of termination and notice requirements and so on. So through the pandemic, there have been scenarios where companies have had to downsize and release full-time employees, and there are provisions in the employment agreement on terminations and how much notice is required, or how much what's the proper term, termination pay, and I know that it depended upon the size of a company's payroll, less or more than 2.5 million. I wonder if you just provide some general guidance on termination of full-time employees due to the scenarios we faced.
Yeah, so I'm just going to answer that one directly, if I may, team. So Hugh, I think that I understand your question to be more specifically, what are the effects of the pandemic, or in terms of notice periods and that sort of thing, those types of awards? Is that the question?
No, I would presume that the pandemic doesn't really change what the contractual law is or employment law is on terminations. But for instance, I have a context where we laid somebody off because of the shutdowns and followed the Ontario government allowance for that. And now we're going to eliminate the position overall. So I have to go back to what the status of the employee was before the layoff. And then there's a concept of averaging the pay during the layoff period, as well as when the person was employed full time. So it's kind of a specific case, and I know you don't want to deal with specific cases, but general outline with respect to notice requirements or termination pay.
Sure. Yeah. So definitely that's a tricky situation, especially when an employee is already laid off. But in terms of general principles, the first thing you need to do is look at your employment contract and see if you can determine or speak with legal counsel. I would highly recommend that. I understand that I have a vested interest in that, but especially when it comes to terminations, it really is. If there was one thing that I would recommend paying a lawyer for, or at least an employment lawyer, it would be for looking at your contracts prior to termination. But anyways, you want to look at whether or not those terms are enforceable, whether they're applicable, excuse me, and then whether or not they're enforceable. Because if they're enforceable, then you're just going by the letter of the employment contract. But if not, that's when you start getting into the more complicated analysis of what are they entitled to at common law or judge-made law, which ultimately centers on several factors, including, interestingly, the pandemic, which has actually been recognized in certain instances to lengthen the amount of notice that an employee is entitled to. But the general factors would be, the main one so far would be length of employment, generally speaking. The nature or amount of responsibility is of less importance nowadays originally, but nonetheless, their age, their related ability to find alternative employment, and any other, frankly, particular circumstances that may be found to be relevant in that regard. Because ultimately the question is, how much notice, how much time would they need at the time of termination, looking at that time specifically, how much time would they reasonably need in order to find another job? That's the whole point of the exercise at common law. And so various factors can come in at that point. So I would just recommend to you that before moving ahead with that, and especially given that this employee is already laid off, that you look very closely at your contractual entitlements as an employer and see whether or not those are enforceable, and then prepare your plan accordingly in terms of the monetary entitlement for that employee and accounting for their possible entitlement to common law reasonable notice.
Thank you.
Wonderful. Thank you for that, Liam. Another question that came through in the chat here from Nicola. When someone returns from maternity leave, do they have to work for 12 months before their vacation entitlement for that year?
So Bruce, do you feel comfortable answering that question?
Yeah, so correct me if I'm wrong, but I do believe that vacation entitlement includes any the year includes any time that an employee spends away from work because of something like maternity leave. So in that instance, I don't believe they have to wait another year before taking leave.
And just to reinforce that, that's correct. I mean, like, another way to look at it is the alternative would be doing otherwise would be discriminatory, right? And so, vacation entitlements do accrue according to years of employment, whether or not that employment is "quote unquote" active or not. So to answer your question, yes. To answer the question, no, they would not have to.
Wonderful. And Sam, I see that your hand is up. Do you have another question as well?
Yeah, actually, since vacation pay is populated based on length of service, the entitlement, whether it's 2 or 3 weeks, what defines a break in service? Like I would be under the impression that a break in service would be like if an employee were to quit to take another job and then to come back later, obviously their seniority date, wouldn't be transferred back to when they originally were an employee. But if an employee goes off on like a 3-month leave of absence, for example, would their seniority date be honored? Let's say they started work on January 1, 2018, and they went away for 4 months sometime in 2018. So would then your seniority date be shifted based on that 4-month period where they had no earnings, or would that seniority date for the 5-year anniversary be, would it stay the same?
So I'll answer that one. So just to be clear, related to that previous question with respect to maternity leave, we do know for sure that break-in in the employment relationship doesn't include approved leaves and that sort of thing, nor layoff, nor sickness, injury, that sort of thing. And so I think that you're very right to note the scenario where an employee were to go end the employment relationship, let's say, and go work for somebody else and then come back. But more precisely, whether or not there's a break in the employment relationship, I think really comes down to how long that break is. And so if it's a week, let's say, that's not enough. I think you had mentioned 3 months. I need to get back to you on the specific, because off the top of my mind, there is, if I recall correctly, a very bright line rule here, but oftentimes you see crafty counsel explain that in the grand scheme of things, that employment relationship was maintained over several years despite periodic breaks. And then there are issues of, for example, seasonal employees, where there is that periodic break in employment every year. But nonetheless, for the sake of certain entitlements, that relationship is held to have been sustained throughout multiple years. So the great answer of all lawyers is really, it really depends. So if you have if you want more specific guidance, then you and I can certainly discuss later on.
Thank you.
And Liam, just to quickly add, for your earlier question, I'm sending a link in the chat, and it's just specific jobs and industries that are exempt to the special rules of the ESA. So that includes agriculture and emergency services. So that might help you with your other question.
Thank you. And yeah, this is a great resource. Everyone, I'm going to put this actually in the chat right now, is the government has a guide to the Employment Standards Act, which covers any and all aspects of it. And truly, it is a fantastic resource for business owners such as yourselves. Just in case you want to refresh yourself or look into a specific thing, it really is a great resource to check out.
Perfect. Well, thank you so much, Liam. I don't mean to cut our discussion short, but we have run out of time for today. Lots of links here in the chat. I've also included my email address. If you do have any additional questions, feel free to send them my way, and I'd be happy to pass them along to today's presenters. And like I said, this recording and all of the resources will be available either end of day today or early tomorrow. And I just want to say thank you once again to each of our presenters, and thank you to all of our viewers for joining us today. We hope to see you at our next Pro Bono Student Council presentation, which is titled Diversity and Inclusion. And that will be happening next Thursday, March 24th at 8:30 a.m. So thanks very much, everyone, and I hope you enjoy the rest of your day.
Thank you.